matter under advisement. Before I call the next case, I did want to recognize we had several groups of people come in during this last case, and we had one group depart. If we had a representative from each group stand up and tell us who our visitors are, that would be great. Yes, ma'am.
Your Honor, we have a large body of senior U.S. government students from Topeka West, who is Justice Rosen's alma mater.
Very good.
Welcome, Chargers. Good to have you here.
And what was neglected to be mentioned is that Justice Rosen is in your Hall of Fame.
That is correct.
Very good. There's a group, this is all one group filling up the entire courtroom?
Yes, Your Honor.
Wow. Very good. Welcome. Now call the next case on this morning's docket. It is case number 105872, State of Kansas v. Kedren Littlejohn.
May it please the court, Kate Zigton on behalf of the appellant Kedren Littlejohn. I'd like to reserve 4 minutes for rebuttal.
4 minutes is granted.
I've apparently scared the high schoolers away.
Don't take it personally.
I will not. I submitted 2 609 letters on this case, in part because the court has really drastically reconstrued alternative means and multiple acts since I submitted my brief 18 months ago. I'll start with the multiple acts issue. I really only intend to cover those issues I have 609 and rest on the brief for the remaining issues. The interesting fact about this case is our argument is that there is essentially 2 causes of death, which is...
Where do you get that? How does someone die twice?
Well, I'm not saying that he died twice, because obviously that's impossible. But what the coroner testified to is that independently, the gunshot would have killed him, the vehicular trauma would have killed him.
Wasn't it the vehicular trauma that killed him?
I believe on cross-examination, she testified that both would have killed him, but they certainly killed him together.
Well, that isn't how you read the coroner's conclusion, though. The coroner's conclusion was he died from the almost immediately from the vehicular wounds.
I believe my recollection of the record is that on cross-examination they did clarify that both would have killed him, but certainly together both independently would have killed him, but certainly together they did. And I think because there is a time lapse and an intervening circumstance that it can be considered 2 separate actions that both contributed to cause his death. I will admit it does make some sense that you can't kill someone twice, but I think in this case where you have 2 things that contribute and independently would both have killed him, if not but for one but the other, that it does make sense that this is a multiple acts case, especially when you look at the timeline of the offense. The facts are that the co-defendant shot the victim in the head, left him in the street, got into the car, drove the car down the street, saw that aid was being rendered to the victim, turned the car around, and then caused the vehicular trauma. It's our position that those are 2 separate acts that require a multiplicity instruction because of the intervening time and a fresh impulse to prevent aid from being rendered to the victim, almost to make sure that he would die.
Where your argument falters is you couldn't have had 2 charges. There's only 1 death.
That's true, but I think that there were 2 charges in the robbery and the kidnapping. Neither were complete until they left. I think both are contributing.
But that's what we look at with unanimity, is whether there were basically 2 separate criminal acts that could have been charged separately, but there was only 1 charge, and so the jury may not be unanimous on which of the crimes were committed here. In this case, there couldn't have been 2 counts. You agree that there could not have been 2 counts?
I agree there could not have been 2 counts of homicide.
Yeah.
But I think part of the multiple acts issue is that there is a fresh impulse, and you would defend the shooting and the vehicular trauma slightly differently if the jury was required to find both by unanimous verdict.
And also, let me just back up here a little bit. This argument was not made to the trial court, was it?
No, it was
In
not.
fact, you brought this, it wasn't even made in your brief. You brought it up in the 609 letter, didn't you?
I did make this argument in my brief regarding 2 causes of death. I clarified it in the 609 letter regarding the changes to multiple acts.
But the request, at least for the unanimity instruction based upon multiple acts, was never addressed at district court.
It was. The district court, when they went to start the instruction conference, wanted to give a multiple
Not
acts.
based on this theory, though. It was based on the fact that it wasn't based on the multiple acts because there was 2 separate possibilities of death. It was based upon the underlying offenses of aggravated robbery and aggravated kidnapping. And in fact, your client didn't bring that up. It was the court on its own that brought it up, and the state clarified. That's pretty much what happened, at least as I read the record.
Well, I think a multiple acts instruction is a multiple acts instruction, and that the jury would have read it with the instructions as a whole. And even if the defense did not specifically request the instruction, I think it's still appropriate in this case under that theory.
But that theory, go ahead.
I think that part of the issue is that this is slightly distinguishable because from other cases where we're not trying to separate out a specific blow, like in a beating death, or in the Kesslering case, which the state cites, where there's multiple movements within one kidnapping. I think that this is different because we have 2 very separate and distinct actions to try to cause the death of this individual. And so I think that's the distinguishing factor that makes it a multiple act. And I think that was...
Again, that was never argued to the trial court, that theory. The theory that it was a multiple acts case or it needed a unanimity instruction was based upon the aggravated kidnapping and the aggravated robbery.
I believe that is correct.
Okay.
But I still believe I can raise it on appeal, and even if the court reviews it under a clearly erroneous standard, because the issue of a multiple acts instruction was addressed at the trial court level. I think there is evidence of confusion here as well. The jury did have some questions regarding the causes of death during their deliberations, which I cited those in my brief, but I did not quote the language to my dismay as I stand here. I'll move on to the felony murder issue, which was contained in my brief. I believe that a lesser included instruction should have been given in this case under the Berry rule. They did not request lesser included instructions at the time of trial because Berry had not been published or decided yet. However, I believe the Berry precedent does allow for the defendant to raise this issue for the first time on appeal.
And those weren't requested either, were they?
No, they were not. However, I do believe that second-degree murder should have been instructed on here, certainly under the intentional aspect of secondary murder. There's no question that these actions were intentional. And so the jury should have been instructed on intentional second-degree murder. And I think that's
How was your client's actions intentional with regards to the homicide?
Well, my client wasn't exactly responsible as the shooter or the driver in the homicide. His liability for these offenses came as an aider and abettor for the robbery and the kidnapping charge.
Right. So how do you benefit then from a lesser included intentional instructions how are they factually supported in this case?
Well, I believe they're factually supported by some of the evidence that these people acted in concert and intended to commit this robbery, intended to then kill the victim. If my client is going to be responsible for the acts of his co-defendant, even if they're reasonably foreseeable or because they agreed to do it, the jury should have considered the intentional instruction, and I think that is particularly reflected because they did not find premeditation, but they could still have found intentional actions on both the part of the defendant and the co-defendant. The state, in their 1609 letter...
Excuse me, I want to back you up. If you aid and abet on the second degree, that would require your client to have also had the intent to kill.
Well, I think that can be derived from the fact that my client did possess the gun during the offense, and in fact he gave the gun to the to the shooter, who then went and shot the victim. The evidence supports that my client got in the car, and then when the shooter went to the car, he gave him the gun, went back, and shot the victim. I believe that was the testimony supported at court. So the act of giving the gun to the shooter, who then immediately shot the victim, I think does support an intentional instruction on behalf of my client. The state urges this court to consider the amended statutes in the harmless error analysis on our request for a second-degree instruction. I don't know that raising the amended statute is appropriate in a 609 letter. Even if the court does just consider this as part of the harmless error statute, I think that, one, this is an issue for remand because we're going to have to litigate significant ex post facto issues, which is not appropriate to do through a 609 letter. But secondly, this court found in State v. Wells, that a defendant does have a substantive interest in lesser included offenses, and that amendment of the lesser included offense statute was not simply procedural.
Didn't you raise an issue in a 609 letter that's beyond the propriety of that with your multiple acts? I mean, I'm kind of curious that you're bringing up the impropriety of the state doing it, but didn't you do the exact same thing?
I don't think so. I raised the multiple acts issue in my original brief. I don't think I changed it from there.
Or you changed the entire theory of it.
I did not intend to change the theory. I believe that what's stated in my brief is what I supplemented with the 609 letter. The last issue that I will briefly cover before running out of time is I think that part of the issue in this case and that prejudiced my client's ability to prepare his defense is that there were a multitude of charges with multiple alternative means, which ends up in a quagmire which both hinders preparation of a defense and I think also led to some confusion on the part of the jury, because we have felony murder under 2 alternate theories, and then there's alternate means for each of the alternate underlying felonies, so that if essentially my client is forced to defend a variety of alternate means, which makes defense from a practical standpoint particularly difficult. So that he's unable to. Is the way
you remedy that, at least you're talking about the charging document, correct, and the difficulty in preparing a defense based upon the charging?
I don't believe the charging document is flawed. I believe that they do charge a crime, but I believe when you charge that many crimes with that many alternate means, it does deprive the defendant of a significant notice in order to prepare a defense. And
there's an absolute remedy for that for your client. That's a bill of particulars, isn't it?
Even if we filed for a bill of particulars, there is, under our theory that we have multiple acts here, it just becomes too confusing. A bill of particulars could have just simply stated all the same facts and left the defendant in the same position of being unable to defend each alternative means. It should have been raised before the district court, but I think that this court can consider this because it's a constitutional issue that's a question of law. With that, I am out of time, and I would stand on my brief for the rest of my issues and ask that the court reverse my client's conviction and remand for new trial.
Any further questions? Thank you, counsel.
May it please the court, Assistant District Attorney Matt Maloney for the state. I will try and limit my remarks to the issues that have been addressed by counsel today at argument, taking them, I think, in the order that they were raised in the brief. First would be the issue with respect to felony murder and whether lesser instructions were warranted. I guess first I'm a little perplexed as far as counsel's assertion that the 609 letter was not the proper way to raise this. I think this is the textbook example of what a 609 is for, is to raise issues or new authority that's come to the attention of the parties since the case was briefed. Obviously, the legislative amendment was passed after the case was briefed, and it directly bears on an issue that was raised in the brief. So I think that was really the only way to get that matter before the court properly, was to file a 609 in advance of argument. Our position in that 609 letter is that the amendment does apply. It tells us that it is retroactive and that there are no lessers of felony murder. I know that this court heard an argument on this issue yesterday in another case originating out of Sedgwick County, and I don't think that I would have any different argument to make than what you heard from Ms. Isherwood yesterday with respect to why we believe that the amendment does apply. Clearly, the statute itself.
What about our determination in State v. Wells that it's a substantive issue, and the legislature can't tell us that it's not a substantive issue once we determine that it is, can they?
Well, I think the legislature is always free to say whether they consider it procedural or substantive, but of course this court is not bound by that. I would argue, of course, as far as Wells goes, I think that Wells can be distinguished because that was clearly decided before the most recent amendment. But as to the underlying issue, I think when you really boil the analysis down, the ultimate question becomes whether there's an ex post facto consideration here, because the amendment itself does say that it's retroactive and it's procedural. I think then the only way that this court could find otherwise is if it concludes that it's a ex post facto violation. Our position is that it is not an ex post facto concern. First of all, that the amendment does not affect the crime that was charged. It doesn't affect the punishment. It doesn't have anything to do with the evidence that is allowed to be presented at trial. It simply is what we would consider to be, as the legislature does, a procedural change as far as the instructional matters.
Well, it most certainly does on the evidence at trial. If there's a second degree intentional here, then the jury has to find that Mr. Littlejohn had the intent to kill and aided and abetted in the killing rather than aided and abetted in the underlying felony. And then with regard to the impact, if he had been convicted of the lesser, would he be serving significantly less time than a first degree?
Well, clearly, on one level, I understand what Your Honor is saying, but on the other hand, I don't think that whether the amendment applies or not, the evidence is what it is. The amendment has nothing to do with whether certain evidence can be presented at trial or not. Even if this case were to be charged and tried today after the amendment, the defendant is always going to be able to present his theory of defense, and he wouldn't be precluded from presenting any of the evidence that you just mentioned, Your Honor.
But if the theory of the defense it's not this, but it's that, and that is a lesser included, it certainly impacts. And I understand going from here forward, there's probably no question about that. But at the time, certainly there would have been a question of what perhaps could have been presented with respect to lesser included.
And I think this case is somewhat unique because it was charged as both premeditated and felony murder. And so if this particular case were to be retried or were to happen today, clearly he could still aim for the lesser included with respect to the premeditated charge. And clearly could argue that intentional second-degree murder was warranted as an instruction as a lesser of the premeditated charge. But again, our basic position is that this simply affected, it is a procedural change. I recognize that this court is not strictly bound by what the legislature tells us. I do think it's telling that in a lot of the U.S. Supreme Court case law, the court has recognized that in non-capital cases, the right, such as it were, to lesser included instructions is not a due process concern, that it's something that's based on federal criminal procedure. And the court has never found, and has specifically noted that they have never found it to be a due process concern. And I think that further bolsters a finding that this is a procedural amendment and that it can in fact apply and should in fact apply retroactively.
Could you get to the factual support just in this case?
Sure, yeah, and that was where I was turning next. Even if this court does decide to apply the Berry standard, I would ask this court to focus on the language in Berry and in the statute that talks about how lessers are warranted when there is when a conviction of the lesser would be reasonably justified. And I know I've made this argument many times that I think that the word reasonably cannot be stressed too much in this situation. The defense's argument basically with respect to second degree intentional is that there was evidence that this was an intentional act and therefore the instruction was warranted. I would submit that if that were the standard, if it were that easy to get lesser included instructions, then there would never be a premeditated murder in which the court was not automatically obligated to give a lesser for second degree intentional, because clearly the only difference between premeditated and second degree intentional is the premeditation element. Our position, though, is that on the facts of this case, there was no evidence that would have reasonably justified a conviction for second degree intentional. First, I would note, as Your Honor did, that this is, under the premeditated theory, the second degree intentional, we would have to show that the defendant's he intended the death under the aiding and abetting theory. And I think that the evidence presented at trial is quite contrary. His defense essentially was that he had no idea.
But you prosecuted on a first degree premeditated, and that has the same intent, specific intent requirement for aiding and abetting. In fact, we specifically said if you're going to aid and abet in a first degree premeditated murder case, then the aider and abetter has to also have both the specific intent and the premeditation. And you prosecuted on that theory, and now you're saying you didn't have the evidence for that?
Well, I'm saying that when you look at the evidence as a whole, you see that clearly the state believed that there was evidence of premeditation. That's why we charged it as alternatively as premeditated and felony murder. But I think that basically to boil down my argument, I think when you look at the facts of this case, I can't think of a more prototypical felony murder case than what we've got right here. I don't think
But the charging prosecutor apparently didn't think so. I mean,
Well,
it was charged in the alternative.
I think it was a prototypical example of both, and I think that's why we charged it as such. I think that on the facts here, it was undeniable on the evidence presented at trial that the two defendants went into this place intending to commit the aggravated robbery.
We understand that, but the point is, if you thought it was a first degree premeditated and the facts were there, then why weren't the facts also there for the second degree?
Well, and that's where my point is reasonably. Under that standard, if I'm understanding Your Honor's question, then in any case in which a state charges a premeditated murder, an instruction on second degree intentional would have to be given, because if you're charging premeditation, then you're automatically saying that there's intent.
Was he instructed on premeditated first degree murder?
Yes, he was charged and instructed on both the premeditated and the felony murder theories.
Position, as I understand it, is there is no evidence, or at least insufficient evidence, of premeditation. I'm sorry. I understand what you're saying now.
Okay. Yeah, our position simply is that it would not have been reasonable for the jury to convict of the lesser. And again, I think you could go through any number of scenarios, and that any time there's a premeditated murder charge, if you were to read out the word reasonably from the statute and from the case law, you could go through all the way down the list of murders and say that you have to just automatically instruct on those offenses.
And I just recalled I was attempting to say earlier, basically you're arguing that the evidence of premeditation is so great that no jury could have reasonably convicted for second degree intentional murder.
Exactly. And I recognize that in this particular case, for reasons known only to them, the jury did not elect to find guilt on the premeditated theory. I clearly disagree with that decision on their part. I think that when you have evidence that they shot the man and shot the victim at point blank range in the head, and then...
Which is precisely why we leave it as a jury function. And that's why we don't gatekeep which charge that we think the jury should convict on.
Well, I think that there is a gatekeeping role for the trial judge in deciding what instructions are warranted by the evidence based on the legal theories of what crime would be supported on the fact. It's not simply carte blanche that you let a jury go back and say, here's the Kansas statutes, pick one of these crimes that you think fits. There is a gatekeeping function. The judge does have to make the determination. And I think that it's telling that the defense did not request any lessers in this case. To me, that suggests that everybody who was in the courtroom and heard the evidence and realized what the theory of defense was, realized that this was a case that essentially for the defense was, his theory of defense essentially was to say that he had nothing to do with this, that he was there for a job interview and was essentially just forced at gunpoint to go along with his co-defendant. So I think that we can't ignore the reality of how the trial played out and what the jury's determination was in this count and in this situation. So again, to sum it up, my argument is that I don't think that a jury could have reasonably convicted of the lesser while acquitting him of felony murder, and therefore I don't think that the lesser was warranted. Turning to the multiple acts issue, I think first of all, Your Honor, Justice Rosen is correct. This particular argument was not made to the trial court. Before the trial court, it was the judge sua sponte that was at first planning on giving a unanimity instruction because he didn't appreciate the distinction between alternative means and multiple acts. And then when the state pointed out that the underlying felonies are actually alternative means, the court realized that that was mistaken. The defense never advanced this theory that the two separate causes of death, such as it were, required a multiple acts instruction. So my primary argument is that, first of all, these are not multiple. This issue was not raised below, which obviously affects the standard of review. As to the multiple acts issue in general, first of all, the coroner's testimony was that the cause of death was the blunt force trauma caused by the vehicular incident. She did testify that the gunshot was a contributing factor and that it could, in her opinion, it could have eventually led to his death had he not been run over. I don't believe that she conclusively said that it would have. She indicated that she thought that it was possible, but that obviously that ended up being irrelevant because he was killed by being run over before the gunshot wound really could do anything along those lines. Clearly, he only died once. There was only one cause of death here. And these were not, even if you look at the general multiple acts test, these were not separate, distinct acts. I think that it's easy to get sidetracked by the fact that there were different instrumentalities used, that there was a gun and then there was the vehicle. But I don't think that that should matter, and I believe I made the analogy in my brief that if a defendant is in the process of stabbing somebody repeatedly and is clearly intending to kill by the stab wounds and then ultimately ends up pulling out a gun and firing a shot which proves to be fatal, that's not multiple acts. It's all one act. Yes, there were different instrumentalities. I think to some extent the record might explain that because the defendant gave a statement in which he said that after the gunshot that the gun was empty. So that might explain why they ended up choosing to run over the victim rather than just using another gunshot. But when you look at this was all at the same location. It was moments apart. There was not, the defense was unified to this. There wasn't a defense presented saying, oh, well, yes, I participated I was a willing participant in the gunshot, but then I didn't want to run over the victim. The defense was unified, which was that he was simply along for the ride because he had been forced at gunpoint to go along with Bogus during this event. So I think when you look at it under just the general multiple acts test, even if you're to give credence at all to the defendant's argument, it fails because of the factors that are addressed in the multiple acts analysis. I see I'm out of time. I think the last issue, with the court's indulgence, I'll just briefly touch on the charging document, and this shouldn't take me more than 30 seconds. Your honors are correct. If the defense has said today that they're not challenging, that they're not arguing that the complaint failed to state a crime. They're simply arguing essentially the sufficiency of the charging document. That is an issue that is to be addressed if the defense has an issue through a bill of particulars. I cited a case from this court, Byrd, in my brief, indicating that if a defendant goes through an entire trial and never raises this issue, that essentially the matter is waived. And I would ask this court to apply that. If the defense truly felt like his defense was prejudiced, then there were any number of opportunities for him to bring this matter to the court's attention or to the state's attention. He did not do that. The transcript shows that his defense was not prejudiced. He clearly knew what he was prepared to defend against. So for those reasons, we would ask the court to deny relief. If there are no further questions,
Any questions?
we would respectfully ask that the defendant's convictions be affirmed.
Very good, thank you.
There are just 2 points that I really want to rebut from the state's argument. One, it is the trial court's duty to instruct on lesser offenses, and I think that the trial court did not fulfill that duty and that there is evidence of an intentional crime, particularly when the state charged premeditated murder. The other issue that I want to address is that even though a defense of compulsion was presented at the trial court level, that's not fatal to this argument. This court found in King that even when the defendant takes the stand and testified, I didn't have anything to do with it, the court could still look at errors. It essentially says that if your client testifies a certain way, that doesn't preclude other defenses from being raised. And even though the defendant testified he was compelled here, I don't think that precludes an instruction on second-degree intentional murder.
What's your thought about the absence of premeditation when Bogues is behind the wheel, your client's aiding and abetting in that crime is the theory, and is several blocks away and aims at the victim here and drives over him, or goes and gets out of the car, tries to get him back in the car, goes back to the car, gets a gun, goes back and shoots him in the head?
I'm sorry, I may misunderstand Your Honor's question. Are you asking how I believe my client contributed to an intentional act in the vehicular trauma part or the shooting part?
No, you're saying that there's a duty to instruct on all lessers, and I assume you're saying that the lesser of first-degree premeditated murder is second-degree intentional. Is that what you're saying, or is it part of the felony murder?
I think it's part and parcel of both. I think it was error for trial counsel not to request it since there was a premeditated instruction on the table, and I think they got blindsided by the felony murder issue not being able to have lesser includeds.
Who got blindsided? You never even requested anything.
Well, I don't think that maybe blindsided is the wrong word. I don't think that they were cognizant of requesting a lesser included because the felony murder was probably the primary theory of prosecution, even though they did present and charge premeditation.
Okay, so what supports your request for the supports your request for a second-degree intentional?
I still think that because even though there was only one death, you have two contributing factors, especially when the state charges premeditation, that these people agreed to kill. Even turning around, we don't know what was said in the car, agreed to kill this person, especially when my client handed Mr. Bogues the gun. Maybe I'm sacrificing one argument at the expense of another, but they're either in it together or they weren't, and that's what the state charge was premeditated.
Okay.
Well, the mechanism of death changed, but how else was there a fresh impulse? I mean, if the first act of your client was to hand Bogues or Bogues, however you say his name, the gun, doesn't, under your theory, isn't that showing that he had an intent to aid and abet in some act of the death? So why does changing the mechanism create a fresh impulse?
Like I said, I think I'm sacrificing one argument for another at this point, which I'm not sure I intend to do. But if we're going with there is one killing and it's all one and it's not multiple acts, and I think that my client's contribution to the initial cause of death and then the subsequent ensuring of death, I think that supports the intentional. If there's no further questions,
Any further questions? Any further presentation?
no, thank you, Your Honor. I'd cede my time.
Thank you both for your arguments this morning. Court will take this matter under advisement.